Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joot, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court of India for the first time used an artificial intelligence software driven by natural language processing for live transcription of its hearings. The live transcription has been launched on an experimental basis. The Constitution Bench, headed by CJ Chandrachud, in the matter pertaining to the Maharashtra political crisis, put a screen facing the lawyers, displaying the live transcription of court proceedings. The CJI told the court that they are seeing how the technology works, at least in the constitutional matters, so that they can have a full record of arguments. The Supreme Court denied Uddhav Thackeray's faction's prayer to put an interim stay on Election Commission of India's order handing over Shiv Sena's rights and symbols to Eknath Shinde faction. A three-judge bench comprising of CJI Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala, however, issued notice to the Commission in the petition filed challenging the decision. Senior advocates Kapil Sibal urged the court to maintain the status quo by arguing that the offices and bank accounts of the party are being taken over by the Shinde faction. The CJI clarified that the contention doesn't form the part of the order and therefore it cannot take a call. In interim relief to Assam MLA Akhil Gogoi, who was booked and arrested on terror charges during the nationwide protest against the Citizenship Amendment Act, the Supreme Court has restrained NIA from taking him into custody until next hearing. The activist turned politician has filed an appeal against the Guwahati High Court order, whereby his discharge order in connection with the offences under the Unlawful Activities Prevention Act 1967 was set aside. Gogoi has been booked under Section 120B, Criminal Conspiracy, 124A, Sedition, 153A, Promoting Enmity between different communities, and 153B, Making imputation and assertion prejudicial to national integration of the Indian Penal Code and various UAPA provisions. He has been elected to the State Assembly during his incarnation, defeating the BJP's candidate. Subsequently, Special NIA Court released him and 4 others after 1.5 years of incarnation on the grounds of non-availability of material to frame charges. However, earlier this month, Guwahati High Court set aside the special court order and remanded the matter back for fresh charge hearing against all 4 accused. Gogoi approached the top court contending that his conduct during the protest was not in line with destroying the national integrity and any terrorist activity. Producing clarification on its earlier order, whereby it allowed the couple registered with the Central Adoption Resource Authority to adopt child of a woman who was denied to terminate pregnancy, the Supreme Court has now said that the permission was granted pertaining to extraordinary circumstances of the case. The 3-judge bench headed by CJ Chandrachud has stated that the order is not meant to supplant this regular adoption procedure of Central Adoption Resource Authority. The woman, a 21-year-old student, had pleaded the court for permission to terminate 29-week pregnancy. The court, after relying on expert medical opinion that there was high probability of the baby coming out alive, persuaded the woman to deliver instead. She agreed to do the same, but also expressed that it will be difficult for her to keep the child. The court, during the course of the hearing, was apprised by the Solicitor General that a couple registered with the Central Adoption Resource Authority has shown willingness to adopt the child. The court then went on to pass the said order for facilitation of the adoption. It has now been clarified that directions were issued in the exercise of its jurisdiction under Article 142 of the Constitution, having regard to the extraordinary situations which emerged before the court involving a young woman in distress who moved the court at a later stage of her pregnancy. The Supreme Court has dismissed petition filed by a law student seeking menstrual pain leave for female students and working women across the country, suggesting that the issue is entirely a policy matter. A bench headed by CJ Chandrachud and comprising of Justice P.S. Narasimha and Justice J.B. Pardiwala, however, granted liberty to the petitioners to make a representation before the central government. The bench showed consonance with the caveated law student's submission that compelling paid menstrual leave in the labour market would automatically operate as a disincentive to engage women as employees. The lawyer, Advocate Shailendra Mani Tripathi, has urged in the petition so filed that the issue has been knowingly or unknowingly ignored by society, the legislature and other stakeholders. It was his contention that depriving women of menstrual pain leave is violative of Article 14 of the Constitution. The Supreme Court for now has kept the question of law as to whether poking at private parts amounts to penetrative sexual assault or not, as it rejected appeal against Kerala High Court judgment wherein it was answered in negative. the High Court, in modification of trial court's conviction of the accused from penetrative sexual assault to lesser offence of sexual assault, had held that the poking one's finger at the vagina of a minor doesn't amount to the act of insertion into private parts to attract the offence of penetrative sexual assault under the Protection of Children from Sexual Offences Act. The genesis of the case lies in the deposition of a 12-year-old minor girl who suggested that the trespasser allegedly poked at her private parts as she described the incident in Malayalam. Based on this, the High Court reasoned that the word kutti used by the minor indicated poking and insertion and not insertion, and thereby accused cannot be charged for penetrative sexual assault. Next we have Delhi High Court. The Delhi High Court has sought centre's response on petition that pointed out that no penal code is in operation in the Union Territory of Jammu and Kashmir at present. The petitioner, Advocate Anubhav Gupta, mentioned before the bench that Section 18 of the Indian Penal Code, which defines India as the territory of India, excluding the state of Jammu and Kashmir, remains unamended even after repealing of the Ranveer Penal Code in 2019 after the region was given the status of Union Territory. The Union Government in August 2019 brought in the Jammu and Kashmir Reorganisation Act 2019 and repealed the Ranveer Penal Code 1989. It was argued that while changes were made to the effect of the former, Section 18 IPC still says leaving the territory of Jammu and Kashmir with no penal code. It is in this regard the petitioner has sought quashing of Section 18 of the Indian Penal Code, being violative of Article 19(1)(d) and 19(1)(e) of the Constitution of India. The Delhi High Court has allowed the petition filed by Hermes, a French luxury brand, to declare its popular H mark as a well-known trademark within the meaning of Section 2(1)(zg) of the Trademarks Act 1999. The single judge bench of Justice C. Hari Shankar observed that the material placed on record satisfies the criteria enumerated in Section 11(6) of the Trademarks Act, read with Section 11(7), which sets out the factors which are not to be taken into consideration by the registrar while determining whether a mark is a well-known or not. The counsel for Hermes drew attention of the court to the reference relevant section of the public under Section 11(6)(1) and 11(7) of the Trademarks Act 1999 and pointed out that knowledge or recognition of the trademark is required to be assessed vis-a-vis the relevant section of the public. The Delhi High Court has sought the stand of Delhi Government on a plea concerning the mandate of uniform to be worn by the auto drivers in the city, while noting that the ambiguity on the issue is in the permit conditions and the motor vehicle rules. A bench headed by Justice Satish Chandra Sharma granted time to the Government Council to clarify whether khaki or grey colour uniform is prescribed for auto drivers in the national capital. The court was hearing petition filed by Drivers Union, which has challenged the mandatory uniform for auto rickshaw drivers and taxi drivers and alleged that such labelling was violative of the Constitution. The Delhi High Court has dismissed PIL file seeking directions to the Comptroller and Auditor General of India (CAG) for special audit of the finances of Delhi Sikh Gurdwara Management Committee and Guru Hari Krishna Public School Society. A division bench of Justice Manmohan Singh and Justice Saurabh Banerjee dismissed the petition as not maintainable on account of Delhi Sikh Gurdwaras Act 1971 being in place. The court stated that the best case of the petitioner is poor mismanagement and illegal abstraction by the committee and GHPS society, for which they have not followed the due process of law, Rules 50A, DSGMC rules, and have instead chosen the wrong forum for redressal of their grievance, Section 32C DSG Act. The Delhi High Court has held that Google issuing warning to Android users before they download third-party applications or APK files doesn't amount to trademark infringement or disparagement, but rather is industry practice. The single judge bench of Justice Amit Bansal in this view quashed the application filed by Windsor Games seeking to restrain Google from displaying any warning against the use of gaming platform or application on their Android operating system. It was argued that warning placed by Google is devoid of any legal justification and goes beyond the mandate of Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules 2021. Noting that several other browsers also display such warning when viewers and potential users download third-party APK files and applications from their website, the court opined that it is an industry practice. The court also clarified that in terms of the prevailing legal regime, the defendants are required to put in place such warnings so as to guard the users against potential threats. Now let's have an overview of other high courts. The Allahabad High Court has rejected an advocate's plea seeking information on communication and correspondences between government advocates and various officers of the state regarding one matter wherein he appeared for the petitioning party. The single judge bench of Justice Biren Vaishnav observed that it is not a fit case where an ordinary litigant litigating in court is seeking information under the provisions of the Right to Information Act. The court was rather of the view that judicial proceedings before the court in civil application for condonation of delay were at large and could have been contested by the petitioner in the professional capacity as a lawyer, and the attempt to seek details under the Right of Information Act of the correspondences between the government pleader's office and states was essentially an attempt to subvert the judicial proceedings, which could have been contested on the merit by the counsel, the petitioner himself. The Bombay High Court has allowed one petition and directed the insurance company to pay TDS amount deducted from the interest component of the claim amount. A single judge bench of Justice Arun R. Padnekar reiterated that no TDS can be deducted on the interest component, and as such, the deduction done by the insurance company on the interest component of the claim amount is bad in law. The court referred to Rupesh Rashmikant Shah versus Union of India and others, wherein it was held that Section 19A of the Income Tax Act is only a provision for deduction of tax at source. A provision for deduction of tax at source is the said section would not govern the taxability of the receipt. The question of deduction of taxes at source would arise only if the payment in the nature of income tax of the paid. A single judge bench of Madhya Pradesh High Court of Justice Dinesh Kumar Paliwal held that the summon is to be issued at the first instance, as if the summon accused still deliberately avoids the summon, then the court may issue a bailable warrant. However, if after that the accused intentionally avoids the process, then a non-bailable warrant can be issued. The court acknowledged the settled position of law and observed that since the issuance of non-bailable warrants involve interfering with personal liberty, they should only be issued to summon someone to court when summons are bailable. Warrants are unlikely to achieve the desired outcome. Hence, before issuing non-bailable warrants, the court must exercise utmost caution, as the warrants, irrespective of them being bailable or non-bailable, involves highly grave ramification. This should only be used after careful consideration of the circumstances and complete application of the mind, the court remarked. The summon is to be issued at the first instance, and if the accused still deliberately avoids the summon, then the court may issue a non-bailable warrant, it reiterated. However, if the accused after that as well intentionally avoids the process, then a non-bailable warrant can be issued, the court stated. The Madras High Court has observed that every instance of a casual police inquiry cannot be termed as a human right violation. The division bench of Justice V.M. Velumani and Justice R. Himlatha was of the view that though police need to exercise caution while handling cases, they cannot be accused of human right violation at the drop of a hat, as it could be a demoralizing factor to the entire police force. The court didn't deny that there don't exist such incidents where police's brazen approach leads to human right violation. They said they do, but with exceptions. The court opined that in deciding human rights violation cases, there need to be conclusive proof, as there is a very thin line between human rights violation and regular police inquiry. The Bombay High Court, while quashing cheating allegations against one man, observed that middlemen cannot be held liable for mistreatment of bride by groom. The court observed that the allegation against the applicant are baseless and without any substance. It noted that the petitioner in good faith acted as a mediator for fixing the marriage of the respondent and in no way related to the party and bear no responsibility. Moving on to miscellaneous news. Not all living relationships are domestic relationships under the Domestic Violence Act, and a married woman's cohabitation with another man is not a bond that would entitle her to relief under this law, the Sessions Court has observed. The Mirzapur Rural Court quashed summon issued to a man and his family after it emerged that the woman who alleged domestic violence was married during the period in which she alleged to have lived with her partner. While the woman claimed to be in cohabitation with the man, her previous marriage was subsisting during the period. The court cited a Bombay High Court order wherein all relationships do not amount to relationships in the nature of the marriage to get the benefit of the DV Act. If the woman is married, she cannot enter a domestic relationship with another man under the Section 2F of the DV Act. The former Chief Justice of India, U.U. Lalit, has defended the collegium system, saying that it is the best one available and we must ensure that the system survives, thrives and gives us the best possible results. He emphasized that the Collegium, which recommends appointment of judges to High Courts and Supreme Courts, takes its decision after thorough deliberations and after weighing all considerations that the appointment process is not a whimsical exercise. The ex-CGI, while speaking at the event organized by Campaign for Judicial Accountability and Reform on the topic Judicial Appointments and Reforms, brushed off the criticism hurled at the Collegium system that it is restricted to being an exercise to ensure a nepotistic cycle continues in the judicial selection. The judge also offered a glimpse into the process and maintained that it involves a rigorous filtering of the names and there are lots of checks and balances. The Gujarat government has told the Apex Court that it will press for the death penalty of 11 convicts whose sentence in 2002 Godhra train burning case were commuted to life imprisonment by state's High Court. A bench comprising of CJI D.Y. Chandrachud and Justice P.S. Narasimha and Justice J.B. Pardiwala also fixed the bail pleas of several accused in the case for hearing after 3 weeks. It asked counsel for both sides to file a consolidated chart giving such details as actual sentences awarded to them and the period spent in jail till now. The Supreme Court has turned down a plea seeking uniform minimum age for marriage for both men and women, saying that there are some matters which are reserved for Parliament and courts cannot enact the law. A bench headed by CJI D.Y. Chandrachud said that the top court cannot issue a mandamus, an extraordinary writ for Parliament to legislate. Noting that doctors cannot assure complete cure of any disease, that the same does not amount to deficiency in service, the National Consumer Dispute Redressal Commission dismissed a complaint by a senior citizen for not getting the promised result. It was the complainant's case that the clinic promised him a complete cure of his ailment, which involved the softening of the skin after 6 months. Taking into account the nature of the disease and the fact that the clinic did perform an extra year of treatment for free, the NCDRC ruled in favour of the homeopathy clinic, noting that in as much as no doctor can assure full recovery in case of such a hereditary skin disease. The Delhi High Court has said that law interns can enter court complexes in the national capital by wearing a white shirt, black tie and black pant as prescribed by the Bar Council of Delhi. A single judge bench of Justice Pratibha M. Singh also said that the advocates appearing before the courts would have to wear white bands along with the uniform prescribed for them. The Bombay High Court has ordered that the trial going on against Yes Bank founder Rana Kapoor and DHLF promoter Kapil Wadhawan in the Central Bureau of Investigation and Enforcement Directorate cases will be conducted together in special court under the Prevention of Money Laundering Act. In the end, we have international news. The US Supreme Court has heard arguments in landmark case that could transform the internet by scraping decades-old legal protection for tech companies over harmful content on their platforms. The 9 justices begin examining a case related to the November 2015 attacks in Paris, and their ruling is expected by June 30th. This could have a huge repercussion for the future of what appears online. The case stems from a complaint against Google filed by the relative of one of the 130 people killed in the attack, blaming Google-owned YouTube for having recommended videos from the jihadist group to users, which they say encourage the call of violence. Section 230 states that in the United States, internet companies cannot consider publishers and have legal immunity for the content posted to their platforms. The novelty of the case is that complainants are specifically pinning the blame on algorithms, arguing that the highly complex recommendation system perfected by the big platforms are not covered by Section 230. India's National Consumer Dispute Redressal Commission has found both Lufthansa German Airlines and British Airways collectively guilty for traumatic event with one woman passenger who was rerouted without a travel visa for the transit stop. The Commission has asked both the airlines to pay a hefty fine of Rs 5 lakh collectively to the aggrieved passenger. The woman was detained by the local authorities for several hours in Copenhagen. Her return to India was only possible after her husband, a retired High Court judge, intervened and spoke with the authorities in Denmark. She returned via Turkey and the overall delay in her itinerary was 13 hours. Adjudging that the woman suffered on account of deficiency in service, the Commission remarked that the curtailment of liberty, even for a short duration, is a big matter. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.